May I please?
Yes.
My lord, item 15. So I was supposed to file affidavit. The officer who supposed to swear affidavit was out of station. So I'll file my affidavit tomorrow and let this matter be taken up day after tomorrow.
Item 15.
15 years. I have taken consent.
Mr. Z. Tarak, learned counsel for the respondent. With consent from the other side.
Diki Pangin. Yes, I have.
First of all, listening the matter. Day after tomorrow.
Day after
So
tomorrow.
as to enable him to file affidavit in opposition. Yes.
All right.
Yes.
My lord, I beg to mention item 8. In item 8, my lord, the learned AG has been requested to appear in this matter.
Oh,
Learned AG. He will be appearing in this matter.
okay.
So,
My lords, I appear for the petitioner in item 8.
yes. Can this be fixed on 17th of June?
17th
Of June.
Yes. Any
My lords,
problem?
in July. My lords, in July, if it can be fixed. June, Delhi courts have vacation, so my arguing counsel will not be available if that is not an issue.
July, we will be having our vacation. Then
my lords, first week July.
We have our
July,
vacation out here in Guwahati.
Then last part of July.
Last part of
Please, my
July.
lords,
Yes.
that will be
28th July.
As agreed by learned advocates of both the parties, races shall raise the matter on
28 to 8
28
July.
28 July.
please, my lords.
Yes.
Madam, I beg to mention item number 10 and 11, madam. This connected matter. Madam, I have not yet received the instruction this matter, madam. Can this matter be released after 3 weeks, madam?
Mr. T. Dagam, learned counsel for the respondent, with consent from the other side. First for listing the matter after
3 weeks, madam.
3 weeks.
Lordship, interim may be continued also. Interim may be continued also.
We are allowed
Two
till the
meters.
entire murder pass earlier self-contained.
Deeply.
Not item 1, 2, 3, and 4. These are all 4 applications filed under section 29A of the Arbitration and Conciliation Act. This is for extension of mandate of the tribunal. Your Lordship, this is the third instance actually where we are seeking time. If your Lordship comes to page 28, Lordship would see the previous order.
Is it available in this record?
Yes, my lord. Page 28.
20?
28, my lord. Starts from, my lord, page annexer 2. It starts from page 24, but then 28 and 29 is the final part. At para 15, my lord, on the last occasion, this honorable court was pleased to extend the time till 23rd of May, 2025. Now, since that period is over, my lord, we are seeking for a further extension. The difficulty, my lord, in this matter was that initially there was some dispute as to the fees payable to the tribunal, my lord, because the fees fixed initially was beyond the 4th schedule. So there was an objection from the respondents that it has to be curtailed to the limit of 4th schedule, and that accordingly was corrected. Thereafter, my lord, Justice V.N. Khare, former Chief Justice of India, who is the presiding arbitrator here, he is presently engaged in a Government of India arbitration relating to some oil field. So he is mostly in England and France these days, because it's an international arbitration. So his dates are not available, and therefore, my lord, the next date in the matter, my lord, has been fixed in July. So therefore, we are at this stage, my lord, seeking some further extension. At this stage, my lord, there are respondents of 4, my lord. My lord, the tribunal says that it might take up to 1 year because they have to write the judgment also. These are voluminous matters otherwise involving 4 contracts. This is relating to the contract, Lordship, the road that comes from Gopur side. And then once you enter Arunachal, that particular road leading up to this particular point that I think 14, my lord.
Yes, Mr. Sarkar.
My lord, I will accept my lord notice on behalf of respondent number 1 and 4, my lord. At this stage, my lord, notice may be issued, my lord.
Notice.
Notice, my lord. Two and 3, my lord, the central government is.
I am appearing on behalf of M. Khata, my lord,
My lord.
for respondent number 2 and 3, my lord.
2 and 3.
Yes, my lord.
Sarkar for 1 and
1 and 4, my lord.
one. So all are represented.
My lord.
So you want to file objection?
My lord, for that, my lord, we need some instruction also, my lord, that's why. My lord. Let my lord notice be issued, my lord. We accept notice, my lord.
Heard Mr. B. Pathak, learned counsel for the petitioner, and also heard Mr. R. Sarkar, learned counsel for the respondent number
1 and 4, my lord.
1 and 4, and Mr.
And Sora.
N. Soran, learned counsel for the respondent number 2 and 3.
Yes, my lord.
2 and 3. This application under section 29 dash capital A 4 and 5 of the Arbitration and Conciliation Act 1996 is referred by the petitioner, namely SRK Construction and Projects Private Limited, seeking extension of the mandate of the appointed arbitral tribunal comprising of Justice V. N. Khare, former Chief Justice of India, and Justice V. K. Sharma, former Judge, Guwahati High Court, and Sri Shambhu Singh, former AS and FA, mod in respect of arbitration case number 1 of 2022. Mr. Pathak, learned counsel for the petitioner, submits that the mandate of the appointed arbitral tribunal comprising of Justice V. N. Khare and Justice B. K. Sharma in respect of arbitration case number 1 of 2022 expired on 23rd 5 2025, and the same is required to be extended for another 1 year. But Mr. Soikia, learned counsel for the respondent number 1 and 4, submits that at this stage notice may be issued as he has to obtain instruction in this regard. Taking note of the submission of learned counsel for both the parties, it is provided that notice be issued to the respondents returnable in 1 week,
2 weeks, my lord.
2 weeks. Returnable.
Sometime maybe because I typically feel my lord 2nd July is the sitting. So because of what we felt that if the tribunal is actually not able to give time after July also, the question of substitution of arbitrators might also come. So I believe my lord the 6 weeks time will be better. In the meantime, we'll get to know also what will happen in July, my lord.
6 weeks.
6 weeks.
Returnable in 6 weeks. However, no formal notice is required to be issued since all the respondents are represented by their engaged counsel. This is a matter after 6 weeks.
Extra.
My lord, extra copy, my lord.
No, no, I will finish.
Okay. However, extra requested copy of the petition be furnished to Mr. You received? You have received?
Yes, sir.
Oh.
No, I have
Furnished to
my lord.
Mr. Sora, learned counsel for the respondent number 20 during the course of the day. You have the copy available? with
My
you?
lord, I have. I'll serve today.
So
and
in
the
other matters,
Other cases, my lord, the arbitration case number will be 2, 3, and 4.
rest are same.
The party name is SRK TKZV. The first, the petitioner's name is different, my lord,
Okay.
in the other 3 cases. It will
Same.
be SRK TKZV, the
So,
petitioner,
Mr.
and
Soikia, you are
case number will be 2,
representing-
3.
Okay.
Deeply obliged.
The floor.
Well, the basic challenge in this read petition is in 2021, Milord, the petitioner was awarded with the upgradation of 20-kilometer Jote, Itanagar Jote Road, connecting to Milord FTI, then Jerome Gamli Law College, and so forth there. Now, during the widening process, the department came across that 6 bridges were there, Milord. 6 bridges were there, and these were all in dilapidated conditions. Then thereafter, the department took a decision that the existing contractors should be engaged for dismantling of all the 6 bridges. And accordingly, my lord, we have dismantled all the 6 bridges, my lord. Then out of that, the condition was that you prepare the BOQ, bill of quantity, then we prepare it, then technical sanctions were granted to us. Now thereafter, my lord, what had happened is 2 bridges, we were given the term of the condition while granting the administrative and the technical sanction was that it will be part of extended tender. So out of that, my lord, 2 bridges, Dokoso and Gera Nala, my lord, there they have entered into an agreement with us. So we are executing on extended tender terms. Now, my lord, thereafter, what had happened is, my lord, kindly come to page 73 for a moment, my lord. The rest I'll not go into, my lord. Then I come to the NP order and then this thing. My lord, kindly come to page 73. Page 73 through extended tender, my lord. This is the terms and conditions which they set out that it will be an extended tender. Well, the concept of extended tender is if the principal contractor has been awarded with the work by following due process of law for award of the contract work, then if there is a subsequent change of the specimen or urgency requiring that, my lord, the particular firm can be awarded the work to further proceed with the construction of the works. So my lord has seen this, the method of execution of the works would be through extended tender process. Now, my lord, that Dokoso and Gera, my lord, that part I have already narrated. 2 we have already been awarded, my lord. Now, my lord, kindly see that my lord has already seen. Now, my lord, kindly come. Just I have outlined the fact of the case, my lord. My lord, kindly come to page 30, my lord, the annexure 1. Page 30, my lord. 30. I'm flipping back to annexure 1, my lord.
This is agreement.
Yes, well, this is 10/11/2021. The work was awarded to our firm, my lord. The first agreement, my lord, 10 November 2021, my lord. Well, second paragraph is important for us. Whereas the employer is desired that the contractor execute the work, widening and strengthening of Itanagar Jote Road 20-kilometer hereinafter call the works, and the employer has accepted a bid by the contractor for executing and completion of such works and remedying of any defects therein at the cost of so and so, so and so. Be that as it may, my lord, the first is how we were awarded with the original contract, my lord. Now, my lord, kindly come to page 35.
Yes.
The Honorable MLA writes a letter to the chief engineer, the advisor to the PWD, and my lord, kindly see this paragraph. All the 6 number existing steel bridges situated along the 20 kilometers,
25.
page 35, my lord. Page 35.
Okay. Yes.
This I'm reading from after survey. All the 6 number existing steel bridges situated along the 20-kilometer stretch of Itanagar Jote Road
are in dilapidated states. These single lane Bailey bridges constructed during 90s are no longer traffic worthy. This double lane state highway connecting state capital Itanagar with NIT, FTI, Jarvungamli Law College and other premier establishments assume significance in ushering overall growth of the state in terms of human resource development index and state GDP. The commitment of the state government to keep the surface communication intact and the traffic worthy round the clock therefore cannot be overlooked. Then this paragraph, two paragraphs is important. It is appreciated that Chief Engineer Western Zone has taken initiative in submitting the proposal to Government of Arunachal Pradesh for considerations on priority. It is, however, felt that the process involving sanction, tendering, etc., being time-consuming, the actual commencement unlikely to materialize before 2025. The existing bridges being vulnerable to collapse at any time pose serious threat to life of end user and public residing as astride the road, and their safety should be prime concern and not to be compromised with mere technical and procedural delay. I am therefore of the opinion that PWD may explore the feasibility of engaging the existing contractor, my lord will mark. I am concerned with the word existing contractor of this road who has successfully delivered the upgradation of the road to double lane in linking up this bridge construction works as additional work being as feature of the same line. Now, this we have seen. Now, thereafter, my lord, what the action they have taken is at page 37 by letter dated 31/7/2024, my lord. They have sent it. My lord, we will not read this, my lord. There's only an official communication. Then, my lord, but if may I request my lord kindly have a look to paragraph 3 of this letter. The suggestions put forward by the Honorable MLA appears to be appreciable in view of the earlier discussions on the matter. Therefore, in continuation to all the correspondence on the subject, you are directed to explore feasibility to engage the same agency for undertaking the construction of bridge on urgent need basis. So then, my lord, this file noting was initiated. Thereafter, the matter was initiated in the file, my lord. Kindly come to page 38, my lord. My lord, the main, I'll just request my lord to type copy page 41.
Yes.
My lord will see this, the file number dated 018/2024, subject urgent repair and construction of dilapidated steel bridges on Itanagar Jyote Road. My lord will kindly come to paragraph 1 straight. 6 bridges, steel bridges located in between chainage number 0.966 kilometer to 18.375 kilometer are somehow kept operational by carrying out welding, strengthening, replacement of rusted bridge parts by interim arrangement time to time through MS Bimji Velji Sharotia Construction Private Limited, the existing contractor of the project in the exigency and under obligation to keep the surface communication intact, motorable during the contract duration, repair works, and so on and so forth, my lord, this particular thing. So we were asked to do this work and we carried out. My lord, kindly come to next page at page 42, the recommendations by the executive engineer. Para 9, my lord. Under the prevailing circumstances, it is recommended to adhere to the following norms compatible with CPWD Works Manual 2022, assigning contractor MS Bimji Sarotia to carry out subsoil investigation, design, preparation of structural drawing through consultant followed up with proof check and waiting from IIT and submission BOQ for all the bridges. Composite steel, steel structures, bridges 70 are loading RCC structure likely to take 2 years' time and not feasible in the context of current situation, entailing all weather road within current financial year, expenditure towards SSI design, etc. can met out of the provision already covered in the proposal subject to sanction by the government. The power of the engaging private consultant is vested with SCCE as serial number 3 of Annexure 66A of SOP to CPWD Works Manual 2022. Subsequent, upon the receipt of sanction for additional cost of bridges came to be taken up under the existing contract as per clause 12 of contract agreement. The modalities of price determination is also covered as serial number 32 of Annexure 66. So this is the recommendation. Now, my lord, kindly come. The next page 43, my lord. There's one file noting is there by the SE. In view of the exigency of the project and the above details highlighted by Executive Engineer, Doimuk Division, it is strongly recommended to consider proposal and obtain necessary approval from the competent authority. Please. So accordingly, my lord, the Chief Engineer in the next paragraph has also recommended, my lord. Now next come, my lord, then for approval of HCM, that the type copy is at page 45, my lord. Kindly come to page 45.
Yes.
Serial number 6. As per the feedbacks, stroke documents furnished by Executive Engineer Doimuk, contractor MS BMG Velji Sarote Construction Private Limited, a Gujarat-based firm, has executed 2 highways in the state of Arunachal Pradesh, having both road as well as major bridges, so and so, totaling 5 number under NHIDCL EPC mode referred below, and so the experience is there. Now, Melo, kindly come to para 7, Melo, next page. The methodology. The methodology and terms of procurement can be considered as additional work by. My lord, additional work means adding to the existing contract, my lord, agreement. The methodology and terms of procurement can be considered as additional work by extending the agreement as already applied earlier, similar to Sapa Chain Daja Road NEC project approved wide number so and so. So, my lord, the government in earlier occasions have also adopted the similar method to award the work in the form of extended tender, and they are following the same module, my lord. Now, my lord, kindly come to page 49, my lord.
Yes.
Now here in after, my lord, they said so and so you are directed to take necessary steps to carry out the project at the earliest possible. The original file submitted Doimuk Division concession all relevant. So the file has been initiated, my lord. So superintending engineer, and then page 50, my lord. The same superintending engineer has given direction to the executive engineer to carry forward the work, my lord. Now here comes, my lord, page 51 is important for me. After taking all the official decisions, that is what constitute, my lord, that Pimpri judgment. File noting is an expression of the individual officer unless it is not given to a final culmination requiring the compliance of Article 166, subclause 3, my lord. So now this has come into, my lord. The culmination of all these actions is at page number 51, my lord. Kindly see. 23rd September 2024, my lord. It says, BMG Wells so and so, widening and strengthening of the work, Jote. Kind attention to see. Miller C, pursuant to the approval of competent authority, Miller, in the UO note which you have referred to in page 50, Miller, it has already been approved. Number dated 17/9/2024, you are requested to immediately carry out subsoil investigation for 6 bridges situated at various locations of this highway for conversion from existing single lane steel bridge to double lane bridge conforming to NH specification. The details are, Miller, kindly see this. In the box, Miller, serial number 1, Dokoso, they have entered extended agreement with us, Miller. Then Garanala, the serial number 5. Miller will mark there. And rest, they are trying to go for split, and which is beyond the competency of the chief engineer. CPWD manual, Miller says, if any amount beyond 15 crores, the chief engineer does not have the power to split it unless you don't take the approval from the competent authority. That I am coming to. Malak, kindly come to page 52. The work shall be taken up as additional work, Malak. Kindly mark this. This is their directions. According to their directions, we have complied with and we have executed the works. Malak. हो जाएगा मतलब नहीं पढ़ने से मतलब that my younger says I should read this paragraph. The work shall be taken. Say, may I, my lord? The work shall be taken up as additional work under the existing agreement, subject to the approval of BOQ and technical sanctions. Determinations of workable price shall be based on market rates. The modalities along with the additional performance guarantee shall be decided during the finalization of supplementary extended agreement. Again, the word kindly mark this. Now, thereafter, my lord, after this, my lord, we were asked to dismantle all the 6 bridges. And where we have done, my lord, by page 53, my lord, will come, kindly, annexure 7. Dated 20th/11/2024, my lord. They says, serial number 1, my lord. Kindly dismantle the bridge carefully, avoiding any kind of accident and major damages to bridge parts, and all the dismantled parts may kindly be handed over to the concerned junior engineer for proper office record. Out of 6 number of bridges, your good self may start with those bridges which are free from any encumbrances by providing proper conveyance to the traffic. In the meantime, this office shall pursue for non-encumbrances of other bridges. Also, it may kindly be noted that traffic flow must be compromised. So, pursuant to this order, 20th/11/2024, my lord, at page 53, which we are reading, my lord, then they again sought for the status report, my lord, by a letter dated 20th December 2024, my lord. The status report was given, my lord. They are asked accordingly, my lord, this has been done, my lord. Now, my lord, work status report is at page 55, my lord, annexure 8 series. This is what they say, my lord. Then on 27/12/2024, we have done name of the work, my lord, in the box, serial number A, construction of 6 nose bridges on Itanagar Jote Road. Subsoil investigation work for 6 nose bridges have been carried out and completed. That is what we have done, my lord. Design and drawing have been completed for 2 nose bridges on Dokoso and Garanala.
Yes.
This, my lord, existing bridges on Dokoso, Garanala have been dismantled and bypass road opened for vehicular movement. So we have been complying, whatever the authorities they are directing us, my lord, we have complied with. Now, my lord, even that, my lord, that type copy we can skip, my lord, kindly flip to page 59. Now the problem starts from this, my lord, page 59. By this letter, 23rd February 2025. Out of blue, my lord, you are asking me to hit the road. The great, the popular English idiom, my lord, which says, asking me to hit the road means you leave at once without following the due procedure, my lord. Kindly see this. The chief engineer, AP Itanagar, has directed to stop the unauthorized works of 5 number bridges on Itanagar Jote Road. Copy enclosed. Accordingly, you are hereby directed to stop any unauthorized works other than the one at Dokoso Nala, my lord. Where the Gera and Dokoso, my lord, are seen, we have already done it. Further, the chief engineer, Western Zone, has asked to initiate a file to allow execution of remaining 5 number of bridges in line 1 being executed at Dokoso Nala, my lord. This is the executive engineer. They have done it, my lord. Now what happens is, my lord, DPR was prepared at page 60 to 64, my lord. My lord, in the DPR, my lord, kindly come to page 61, my lord. One paragraph I would read if my lord permits. Para 2 of the history, my lord, kindly come to history, page 51. Page 61, my lord. My lord will kindly mark this particular thing. In exigency, the construction of bridge works had to be started by engaging the same agency, my lord, will kindly mark this. In continuation to agreement work wide number that is so and so, widening strengthening of the so and so, the same agency has been engaged by this office letter number so and so on accord of approval from the government so and so in anticipation to get release of fund and sanction. In anticipation of fund being sanctioned and released, my lord. Then, my lord, we have spent 21 crore rupees. May I request, my lord, to have a kind indulgence to page 67, the type copy of Annexure 11. Now, my lord, pursuant to this DPR at page 61, my lord, in paragraph 2 of the history, my lord, engaging us as an extended tender. Then the government was pleased to accord sanction, my lord. Page 67 type copy. Dated Itanagar, the 11th March 2025. The governor of Arunachal Pradesh is pleased to accord administrative approval and expenditure sanction not exceeding rupees 8,050 lakhs. That means 80 crore 50 lakhs, my lord. In lakhs, the engineers, they always confuse people by using this numerical. As the Itanagar, at a cost for construction of 6 nose, double lane bridges and ancillary work on Jote Road under so and so, restricting element during so and so, my lord. Now, fund has been sanctioned, released, my lord. Now, my lord, kindly come to page 70. Pursuant to this approval by His Excellency, the Governor of Arunachal Pradesh, fund being released for 80 crore 50 lakhs, then the technical sanction was granted, my lord. Kindly see what the chief engineer says. In exercise of powers, I think there was one mode of this thing. No, I'll come to that, page 73. In exercise of powers delegated under para 3.1.1.6 bracket 3 of CPWD works manual so and read with annexure so and so works manual 2024. Technical sanction is accorded to work construction of 6 numbers double land bridges and ancillary works on Itanagar Jote Road for an amount of rupees 7,972.65 lakhs. Only under the head of account number so and so under the budget estimate of 2024. Administrative approval and sanction for total project cost of so and so as accorded by the government. Now, technical sanction has been granted to us. Now, my lord, as I pointed out, kindly technical sanction accorded by the chief engineer and PWD so and so. Page 73, my lord, kindly come. So this, everything has been given, my lord. Now you see, page 73, my lord, the last paragraph, which I read already. The matter through extended tender, page 73. Now, after the fund has been released to the department, some jaundice eyes somehow started heating everywhere. We understand, my lord, how the department works. Kindly come to page 75, my lord. Now, these are the impugn orders, my lord. Kind attention, so and so, so and so and so. Please refer to this office letter number so and so. Competent authority has approved design, drawing, and subsequent accorded technical sanction based on BOQ submitted by you. All this, technical sanction, the fund was placed on the BOQ prepared by us on their directions, my lord. The first thing. Now, why I am agreed by is this serial number 3, my lord. Kindly come. It has been further decided to implement the project during the meeting chaired by Chief Engineer, Western Zone PWD on 21/03/2025 by segregating in 2 parts as under. bridges over Docoso and Granada. My lord will mark this. Thus, they said bridge over Docoso and Granada as extended portion of agreement. So and so for regularization being already executed nearing completion. Now, my lord, what it says in the B3B is the most offending part in this impugn order. Remaining 4 bridges by floating phrase e-tender. My lord is kindly aware. Any decision, this particular impugn order, my lord, that state of Punjab versus Mandeep Singh, my lord, and others, 2016, my lord, 2 SSC page 724, paragraph 4712. The law is well settled. Any administrative actions per se, executive decision must be self-composite and it should be sustainable and must contain reasons, my lord. In this case, my lord, kindly see in this impugn order, I do not find any reasons. You have entered extended tender agreement with me for Docoso and the Granada, and you are now deciding, you have decided that 4 remaining bridges will be for the E10. Where is the rational nexus, my lord? Some rationality, my lord. Even if, I walk with the cake with full of happiness because I'm having the cake at both hands. 2 bridges already I'm having. But another 4, why do you want to eat by yourself? Law cannot permissible, my lord. That is nothing but the arbitrary actions of the authorities, my lord. Can we see, my lord, we are agree by this. You cannot do this. The first place you say you submit the BOQ. We have submitted. Then the fund was released, my lord. Second count. Third count, technical sanction was given. Then thereafter you comes up with an impugn order saying that you should stop the work. And fifthly, you say that to project Docoso and Granada, we are entering extended tender agreement with you. And for the others, you say, no, we are going for an e-tender. But you must give reasons. It must be impregnated with the reasons, my lord. That judgment I will place, my lord. I have this judgment. This is how we are agreed, my lord. You cannot play with us. I have invested so much of money, my lord. Kindly come to paragraph, my lord. Paragraph 16 for a moment, my lord.
16 of?
Of my petition, my lord.
Okay. Yes.
The petitioner begs to state that the executive engineer, Doimuk Division, PWD, Arunachal Pradesh, Doimuk, issued the impugn letter number so-and-so dated, so-and-so addressed to the petitioner firm, wherein the bridges over Docoso and Granada were treated as an extended portion of the agreement. That is what my lord will find at page 73 of my annexure law. That is so-and-so, and the remaining 4 bridges were to be constructed by floating a phrase e-tender. Subsequently, the executive engineer Doimuk PWD division issued the impugn letter number so-and-so dated so-and-so addressed to the petitioner to stop work at change number so-and-so over Pova River in violation of own terms and conditions. You cannot. Well, I remember that there is an old judgment. Government cannot go against its own documents. That means,
there is.
yes, that is one judgment that I have. That when we enter into this domain, then kindly see the doctrine of promissory estoppel. You have promised, you cannot resign. That 2025 judgment is there. I will place that. That is called changing. That is that principle, popularly known as legitimate expectation. And suddenly you cannot change the rules. You cannot change the game of the rules. That also I have this judgment. The suddenly you are changing it. For what? But in your impugn order, you have not assigned any cause and reasons. And then that recently, on 23 of this month, the coordinate bench of this honorable court, referring to my lord, that 1952 judgment, how administrative decision can be examined. And then, my lord, the best is even that Tata Cellular, my lord, paragraph 70 and 94 are the best to be placed into in the service, my lord. Of course, I am not on the merit today, my lord, just I am placing and praising for the interim order, but these are very relevant for me, my lord. Then, my lord, will see that, my lord, we were in page 75, the impugn order. Now, my lord, then what will happen is, the more interesting part is at page 76. Again, the executive engineer writes to us 24/4/2025, stop the work. Then, my lord, kindly come to page 77. How they have somersaulted from their own actions, my lord. That is what I refer to, my lord. 11/4/2025, again they enter extended tender with us for Dofoso Bridge and the Gera Bridge. And my lord, everything is prepared by us, my lord. Whatever they wanted, we have done it. Then, my lord, we have given our representation at page number 104, my lord. This is how, my lord, that pay, we have written everything we have. My lord, kindly come to page number 105, serial number 4, my lord. Para 4, my lord, of this representation. 105, para 4. The rest, my lord, I have already submitted. The technical sanction for rupees 79 crore 72 lakhs 0.65 rupees was accorded wide order number so and so for the construction of 6 double bridges and technical bridges and associated works on the Itanagar Road. The technical sanction explicitly states that the project shall be executed through extended tender, consistent with the government approval from so as reflected in the terms and conditions of the order. We have clearly made it, Miller. Kindly see paragraph 106, page 106, para 7 and 8 also, Miller. Miller, here, Miller, the contention that I have raised is that on your actions, we have spent more than 21.91 crore, Miller, paragraph 7, Miller. And paragraph 8 is important, Miller. That I have made a descriptions also, Miller. Page 106, para 4, para 8. This para 8 is Well, that the decision to the restrict or split the project costing above rupees 15 crores and the subsequent denial of the extension of the tender appears to be inconsistent with the prior approvals, established practice, and the norms outlined in the relevant standard operating procedures and the CPWD works. The practice of extending contracts without first tendering, as evidenced by recent approval example memo number so and so forth, further underscores the arbitrary nature of the current action. Where is CPWD? Well, for a moment, like I place this. The chief engineer do not have the power to speak because it is 80 crore the government has sanctioned. I see. 14 or asset? 14 asset. A pay 8 to 7. 55 to 7. Pays 350 to 7. This is non-resident.
Mr. Tara, page number?
Page number, my lord, I just one moment. Very bad. Well, it's just I. We have not flagged this. We have lost the flag. This is 400 likes, huh? My lord, that part I'll come. So that I'll show it. Now, my lord, therefore, now kindly come to my prayers, my lord. My lord, before the prayers, my lord, may I request my lord to kindly come to para 20, my lord, page 17, my lord.
Yes.
That your lordship's humble petitioner state and submit that the action of the respondent authorities in splitting the work of 6 bridges, which were approved and technically sanctioned as a composite project to be executed through an extended tender, is arbitrary, illegal, and in violation of their own terms and conditions. The splitting of the project cost, particularly when the total sanction cost exceeds 1,500 lakhs, that is 15 crore, to be beyond the competency of the chief engineer as per CPWD manual 2024 annexure 66 serial number 23, is splitting the work to deny the petitioner the right to complete the remaining 4 bridges despite having commenced work based on official instruction, is a clear violation of Article 14 of the Constitution. There is one first ground I'm assailing why this impugn order is not sustainable legally, my lord. Then, my lord, kindly come to para 21 also, that doctrine of legitimate expectation will come, my lord. That Food Corporation of India judgment is there, my lord. That I have quoted. Once you have the, my lord, just I read at page 18 for a moment. The Honorable Supreme Court in the Food Corporation of India versus Kamdenu Cattle Feed Industries 1991, SCC 363, held that doctrine of legitimate expectation can be invoked to challenge arbitrary administrative action, my lord. Therefore, warrants the kind indulgence, my lord. This is principle of law, my lord. Just I'm making a plea, my lord. Then, my lord, kindly come to page 22, my lord. That Ramana Dayaram Sethi judgment I have referred to, my lord. All those I'll indicate the paragraph and all, my lord. You will find out that the respondent authorities have already entered into an agreement dated 11/04/2025, where the petitioner's firm for construction of 2 numbers bridges as additional work under the extended tender method, even after substantial completion of works on these bridges, applying a different yardstick for the remaining 4 bridges where the petitioner has also commenced work under the supervision of respondent authority. It is discriminatory and arbitrary. The apex court in Ramana Dayaram Sethi versus International Airport Authority of India so emphasized that in contractual matters, the state must act fairly and reasonably, cannot discriminate between similarly situated persons. So why I am saying, my lord, for Dokoso and the Gera, you have entered extended terms of contract agreement with you. But in another 4 bridges, you say that we will go for the e-tender procurement. Now, where is your reason? You have not assigned any reasons in your impugn order, page 73, my lord. Therefore, this calls for the interference. But page 25, I have talked about the common cause versus the Union of India, my lord. Arbitrary action by a state is violative of Article 14. There's equality and arbitration are the sworn enemy in terms of our constitutional facet, my lord. Then, my lord, that is what paragraph 26 I have reiterated. Where is that? My lord, kindly come to page 355.
Page
355 in the CPWD manual, where you cannot do it. Serial number 13, kindly you can share with me. No worries. My lord, there's serial number 20, my lord, in the box. Splitting up projects works, subheads, packages, sanction cost of project works, distinct subhead package being criteria. Then, my lord, kindly see the write in the box, chief engineer, 1,500 lakhs. My lord. That is 15 crore only. Other than that, you do not have the power. It is, my lord, the total sanctioned project cost for all the 6 bridges are 80 crore 50 lakhs. So therefore, you do not have the power. But even now here comes doctrine of delegated legislation. If a particular delegate is not empowered to carry out certain powers, you cannot act beyond that. And it is a trite law, my lord. If a X provides you to do a thing in a particular manner, you must do it in a particular manner only. Nothing less.
That is well settled.
It's a well settled law, my lord. No, my lord, therefore, my lord, at the moment, I'm praying, even I'm not going for a stay order also, my lord. Just I'm praying for a status quo order in view of the fact that we have received one instruction that the superintending engineer, the SE, has initiated a note again. Initiated a note. We have just been communicated by now. It is not very legible. In complying with your letter, so and so, during my side, they said ki we will consider your case. I'll file additionally, I will file this in the affidavit in subsequent. This letter they have there. My lord, only at the moment issue notice and then kindly interfere with the kindly direct them to maintain status quo till in respect of another 4 bridges. That much, my lord. Otherwise, I have plenty of case law. I don't want to burden lordship with the case law at the motion stage, my lord.
Yes, Mr. Rotan.
My lord, my learned friend has gone through so many annexures, my lord. My lord will kindly see the initial contract was for 69 crores. That was for construction of and widening of road. That was completed. Somehow, for what reason and through whose initiation, the local MLA initiates a note. Yes, the road has been constructed, completed. Now, since there are bridges which are in dilapidated conditions, that bridges also needs to be expanded. So why not engage the same contractor? The file movement initiated. There is no concrete approval that the 6 bridges has to be constructed by this existing bridge contractor. What has been approved was that yes, these 6 bridges also needs to be upgraded. Now, my lord will see. I will not burden for today, my lord. Without the approval of the government, the executive engineer, he gives a direction to the contractor, you now carry out this. Whereas there was no such approval by the government to award the contract of these bridges. These bridges, the construction of these 6 bridges is more than 80 crores. Whereas his initial contract was for the road was 69 crores. Now it's something like I have constructed a road. Now I will have to, as a matter of right, that I have to be given the construction of bridges also. In fact, my lord,
2 bridges.
even the sanction order, what sanction order, my lord, what is not very clear, my lord, will see at page 65.
Page?
65. My lord has kindly seen this. Page 65, not at all visible, my lord. Legible.
Type copy is there.
Type copy is there. Rightly, they have typed out what should be the correct position, my lord. Dear my lord, may I read, my lord, page 67. The governor of Arunachal Pradesh is pleased to accord administrative approval and expenditure sanction not exceeding to rupees 50 lakhs as the estimate cost of construction of 6 double lane bridges and ancillary works on Itanagar Jotar Road under so and so, restricting the expenditure during the so and so to 8 so and so proposed through EPWD subject to restriction of one asset. My lord, here at serial number 12 at page 68. The execution of works, schemes, projects, and procurement of items, materials, furniture, etc., should be done strictly as per the provisions of GFR, DFPR, CPWD manual, etc. All financial rules and regulations, the guidelines and directives issued by the Government of India, Ministry of Finance, Government of India, Administrative Ministry, Ministry of Government of India, CVC, and Government of Arunachal Pradesh in this regard. This is the type copy, my lord. What actually there was something fishy going on when the administrative approval, my lord, and expenditure sanction was granted. My lord will kindly see what was the original one. This is 11 March, the same thing, paragraph 12. All is same. Government of Arunachal in this regard from time to time should be followed in letter and spirit without fail. Then the work shall be carried out through extended tender as per approval of the government. Right number?
Paragraph number 12,
12.
the execution of the scheme.
You know.
Yes. No, paragraph 12. The execution of the works, schemes, projects, and procurement of items, materials, furniture should be done strictly as per provisions of GFR, DFR, so and so, all financial rules and regulations. The guidelines and directives issued by the Government of India, Ministry of Finance, Government of India, Administrative Ministry of Government of India, CVC, and Government of Arunachal Pradesh in this regard from time to time should be followed in letter and spirit without fail. Then, my lord, the work shall be carried out through extended tender as per approval of government white number 530 dated 17/9/2024. This was inserted. There was something wrong why it was inserted. Now, thereafter, what happened? Soon, this was signed. This was issued on 18/3/2025. My lord. Thereafter, immediately coming to
This your instruction?
yes,
So one line is missing.
yes, one line is missing. But what happened? This one line is supporting the petitioner that it will be executed through extended tender. This one line. Now, my lord will. As soon as this came to the notice of the issuing authority, this was rectified, my lord. This was amended. My lord might have understood why I'm saying there was something fishy going on. Normally, in the sanction orders, the approval, there cannot be any approval saying that it should be through extended tender.
In my favor.
But in this, there was a condition this should be executed through extended tender. My lord has said. Normally, such approvals are because all the financial guidelines, financial rules have to be followed. Why I'm saying, my lord? If this is allowed, then a contractor, it will be like a contractor, he will be able to procure more and more works in the name of extended contract without there being any floating of tender. Here in the instant case also, his tender amount for construction of the road was around 69 crores. Now, by virtue of this, extended in the name of extended tender without there being any tender process. He is trying to procure more than the original tender value, now 80 crores for 6 bridges, which was not there. And this is against the financial rules because every contractor, other contractors are also eligible to participate here. Now, while issuing that administrative approval and sanction, my lord, that condition was given that it should be through extended tender. That was subsequently found out and immediately it was corrected. My lord, just now I handed over, my lord. Why it was corrected? Well, the administrative approval and expenditure sanction number so and so under so and so with an estimate of rupees 50 lakhs with an expenditure sanction restricting to so and so for CFY is cancelled due to the presence of some unintentional errors in serial number 12 of the above modified order. Now, new administrative approval and expenditure sanction order is issued by so and so, replacing superseding the above mentioned order. Now, this because my note knows the financial rules. The executive engineer, with my respectful submission, without the approval of the competent authority, went ahead asking the contractor to go ahead with the work. Now, I have many correspondence between the executive engineer and the chief engineer, where time and again the chief engineer had asked not to allow the work to be constructed, gone ahead by the contractor man. Ultimately, what happened, despite all this, since on the one hand, the executive engineer is allowing the contractor to go ahead, despite the orders of the superior, the chief engineer saying not to allow because that work will have to tender it. Ultimately, there was a meeting and then there was a meeting. Then there,
Which means, it is not matching with my annexures.
yes, no, this is
Malad,
as per instructions.
Malad, the learned additional AG, I have relied on 2 documents. First
Yeah,
one,
I'll
that's one.
provide.
And then,
This will come in our reply.
Yeah, please, then
If-
for
if-
today, Malad, kindly status quo. And
No, Malad,
you come out with an affidavit. Because like this is not part of the records, Malad, as far as.
My lord, status quo, my lord will understand, my lord, status quo will amount to stopping the entire process for the rest of the 4 bridges. He has been awarded 2 bridges, agreement entered with 2 bridges for 2 big bridges. And that was entered in the month of March,
No, April.
April. Now he
11th
comes
also.
after completion. He should not have executed that work if he wanted all the others. Well, he agreed to one part of that order and he agreed to execute 2 bridges. Now, after executing, he is coming that the other 4 also. My lord will kindly see this minutes of the meeting. Now, after completing that rest 2 bridges, now he wants the other 4 and he doesn't want the other 4 to be the tender to be plotted. That is the exact why in the first instance he did not approach this honorable court after so many, after more than 2 months, madam.
No. The impugn order pass was on 24.
No.
See, we are in the right time, Malad. Kindly see,
No,
24, 4,
my lord will
2025.
kindly see the agreement entered. My lord, agreement for the 2 bridges. The impugn order is of March 29 March 2024. 2025, my lord. Sorry.
So therefore,
Yes,
within the-
March. My lord will say March 29 March 2025. There itself, the contractor knew that he is going to be allotted only 2 bridges. He did not come. He thereafter even executed. Entered into agreement for 2 bridges. In the month of April, he started executing because he was already executing 2 bridges. So he continued with the 2 bridges and even entered into agreement for 2 bridges. Now, after completing that, he wants to even execute the other 4 bridges, which the department wants to go for plotting of tender. Now, if status quo in this at this stage will be given, the process for plotting tender also will have to be stalled. In that way, both the public will suffer, my lord. The public will suffer. Either he will continue with the litigation. So, my lord, if my lord will pass any order, my lord will only say to that effect that no, even if the process of tender is is initiated, no final award should be given without the leave of this court. At least the process, if in the meantime he succeeds in his petition, then well and good. But at this status quo will hold everything. We will give our detailed reply back.
If the learned additional AG is done with, number one, he submits that there is a directions by the chief engineer to stop the work and then without following them. But my lord, in the technical sanction and in the DPR in the BBOQ submitted by you has only been approved by the government.
Everything will be explained.
No,
Not everything.
one thing. And thereafter, the contention which the learned regional AG has raised is that by in the curve of extended tender, you want to grab another 4 more bridges. But categorically, we have made a statement. We have already on the directions, my lord, when we took over the work and then we spent on more than 21 crore of the money, all the ducking, sucking, everything is done, Lord. It's only on the verge of completions. Now, if that be the case, so, Lord, there is one in this anti-agency, Lord, that judgment is here with me. Anti-agency judgment has clearly said, Lord, it is rendered on, just I say. Now, this anti-agency, Lord, it was rendered on 23/5/2025 by Justice Medi last week. Referring to this particular judgment, public orders publicly made has to be examined on the basis of the reasons. AIR 1952 SC 16. Now, in the BOQ also, my lord, administrative sanction also, in the DPR also, you said the method of execution would be extended tender. It is none of my fault. And that contention goes in view of the fact that, my lord, once you have entered agreement with us, in this, my lord, particular case, my lord. 1 second. No. Now, my lord, this particular thing will help me. I believe the learned additional AG will agree with me in this count, my lord. Kindly see, my lord. If his contention is to be admitted, assuming not admitting, then, my lord, that 11.4, kindly come to page 77, my lord.
Hmm.
77 to 81, my lord. Because the technical sanction says DPR, it is approved, says that the method of execution would be by me through extended tender. On the strength of that particular judgment order, you have entered agreement with me. So therefore, even by a stretch of imagination, to my conscience, my lord, the contention advised advanced by learned additional AG will not sustain. You have gone beyond one state of your own action. Anything has to be very fair, my lord. So therefore, my lord, my respectful submission is, my lord, since we have received the communication also, the SE has also said that they have written a letter, which I will come, because number two, my lord, all the annexures which my learned additional AG has relied upon is not in the form of affidavit, on instruction, my lord. So because even notice was not issued, how instruction has come, that is one aspect. Anyway, I'm not quarreling with you or not disputing, I'm not putting any blot on the cloth of a white cloth, my lord. In any case, my lord. So therefore, kindly maintain the status quo, because in paragraph 33, my lord, kindly come paragraph 33. I have made a categorical statement, because the learned additional AG has said that the government is
My
is
lord,
going for an tendering and all. I categorically made, my lord, that no fresh NIT has been published for the remaining 4 bridges till filing of this writ petitions. Therefore, the balance of convenience lies with the petitioner, as preventing them from continuing the work would cause irreparable financial loss and delay the completion of a crucial public infrastructure project. This honorable court may protect the petitioner by passing appropriate interim orders
Okay.
by interfering with the impediments.
Okay. Is there any dispute that the petitioner herein has dismantled the other 4 bridges also?
no, my lord.
No.
My lord will kindly see our minutes, what I have provided.
Mm.
My lord will, that will make things clear, my lord.
No dispute.
Because he has entered into agreement for 2 bridges. Now he has done that. Now status quo, if my lord will pass, he will continue
No,
with
no,
that.
no. I'm not asking about passing this status quo. I am asking you
No, my
whether
lord.
he has dismantled the other 4
No, no,
bridges
no,
also.
no, my lord. Those others only he has done these 2 works, 2 bridges.
Page 51.
We have, therefore, my lord, that minutes, what
No,
I
no.
have provided, it's clear. my
No,
lord.
no, page 51, kindly say.
Mm.
Page 53 also is there in my affidavit,
no.
in my writ petition.
Mm.
2011, 2024, page 53. We have done the dismantling and made a categorical statement. If my lord kindly come to
53.
paragraph 10, page 11 and 12.
Page
11 and 12. Para 10, page 11 and 12. Malad, I have made it very categorical. Malad. There is no separation of any material facts. Malad, just I assist the court that paragraph 10, based on the explicit directions and assurances from the respondent authorities, including the letter dated 2011-2024 from the Assistant Engineer Balijan Subdivision PW, allowing petitioner to start work on bridges free from encumbrances. The petitioner commenced work on all 6 bridges except the Bath Nala bridge initially, which was later started after land compensation was paid. The petitioner incurred significant resources and mobilized manpower and machinery at all 6 sites as confirmed by the status report submitted by the executive engineer PWD. Therefore, Malad, this balance of convenience is in my favor. I have made it out, Malad. Kindly status quo till then.
Okay, we'll pass the order.
Great, grateful, Malad.
My lord will only kindly see that minutes.
No, maybe,
may not
but that is not part of the record.
Yes, my lord. That's why before passing
It
any,
may not be
How-
taken on board for the moment, Milord, because let him come by affidavit.
we are therefore saying that without passing any, there should be no interim order so that we can bring out, bring all this in.
Professor Milord, my citations are there. I
Affidavit.
have quoted also.
Prima facie, I am also showing. Affidavit will bring it.
But sir, your documents are in a loose sheets. How it can be
Yes,
treated?
we are therefore, we are
I'm grateful, sir.
praying that
Okay.
let us file our affidavit. No
We'll
interim order.
see what can be done.
Marvelous, marvelous. My lord, as per the order of 30 April 2025, this matter is supposed to be disposed of today, wherein, my lord, the specific direction was made from this honorable court to directed the respondent number 1 to 3 to file the affidavit on or before 22 of this month, so that the matter can be disposed of. Now, my lord, till this morning, I have not been punished. Therefore, out of the curiosity, my lord, I have go through and check the record, and my lord, till morning, I have found that the affidavit has not been filed by the respondent number 1 to 3. That is the deputy commissioner, my lord. Now, in the meantime, my lord, within this, my lord, at 11:30, I have received the affidavit on behalf of the respondent number 1 to 3. So, my lord, still I am not sure whether that record is in the before the lordship file or not.
Mm.
Affidavit in opposition filed by the respondent number 1 to 3. So, my lord, if record is there, my lord, so in such situation, my lord, I am praying for, my lord, 1 week time, because I have to go through the, my lord, affidavit in opposition filed by the respondent number 1 to 3, my lord.
Well, I'm appearing for respondent number 7. Well, the grievances of the petitioner is only in respect with the army who has acquired the land. But, my lord, this compensation, because there is an interim order operating, the disbursement of the interim order is only related, because that my lord, 49.63 square meters of the land, this has already been adjudicated by the trial court. And in many of his appearances before the district deputy commissioner, and also in the title suit, my lord, has categorically made that he has no grievances if the compensation is made. So therefore, some of the remaining portion, my lord, just I see, therefore, this interim order need to be modified, my lord.
My lord, this is only the matter of, my lord, one.
Because
So
this
far,
cannot be.
my lord, the argument is concerned, my lord, this has been taken to
Let
the
us do one thing.
certain
Let
extent,
it
my
go through the affidavit.
my lord.
We'll fix a very short date. We'll hear both the parties.
Fine, my lord, that.
Heard Mr. C. Modi, learned counsel for the petitioner. And Madam Pangopo,
Respondent number for government 123 your lordship. 135 your lordship.
135
Yes, we are
And-
today we are filing our counter affidavit your lordship.
today.
Yes.
Yes, so Mr. Tara for respondent number 7.
7.
And you for
4 and 6.
4 and 6. Mr. Your good name, please? K. Lawyer. Learned counsel for the respondent number 4 and 6. Mr. Modi, learned counsel for the petitioner, submits that he has been served with the affidavit in opposition at what time? 11:30 today.
11:30 he says.
Yes,
Yes.
your lordship, we have
By-
filed your
30
lordship.
AM today. And he needs some time to go through the same. And accordingly, he prays for listing the matter. When?
Third.
Third, my lord.
3rd of June.
Third.
Okay, all right.
Great.
Let's just list the matter on 3rd of June.
My lord, you kindly make a
Nice,
small observation, if my lord doesn't feel guilty, that endeavor shall be made to dispose of.
Okay. On that day, endeavor will be made to finally hear and dispose of the matter.
I am grateful.
Oh.
Lordship,
Yes.
till today I haven't received any of the affidavit from the opposite party.
Your Lordship, we have correspondence, we have made correspondence with the competent authority, Your Lordship. So some two weeks time is granted. Well, I'm appearing on behalf of DSG, Your Lordship. Correspondence
On
number
behalf of?
7 and 8.
The matter was fixed today.
On behalf of?
DSGA, Your Lordship.
Third, Mr. Your good name, please.
Itatak.
Learned counsel for the petition. And Mr.
K. Terry, Your Lordship.
K.
Terry.
Learned counsel for the
And
respondent
DSG.
number
7 and 8, Your Lordship.
7 and 8 and Madam Pango for
3 to 6, Your Lordship.
8 to 6. The learned counsel for the respondent number 7 and 8 submits that he has not yet received the instruction and press for listing the matter after 2 weeks. Where allowed, let's list the matter after 2 weeks.
Yes.
After
Of
2
the
weeks.
Much obliged.
Madam, you have filed your affidavit.
No, Your Lordship, we have not received a Paravas comment, Your
Okay.
Lordship.
Okay, but Madam Pango also submits that she has not received an instruction.
Alright, my instruction is not to press this matter. The purpose has been served
Yes.
by the transfer
You want to
posting order.
withdraw this petition.
Yes, my lord.
Mr. Titi Tara, learned counsel for the petitioner, submits that he has the instruction to withdraw this petition. Here is accordingly allowed, this WPC is not a disposal of withdrawal.
And interim order earlier merged.
Interim order passed earlier, shall merge with the final order passed today.
I am much good.
Much. In view of order passed in WPC number so and so, this I is that's closed. None appears for the petitioner on call, list the matter after 1 week.
Item number 30, perhaps, my lord, the judgment arising out of which, my lord, the contemplation is filed, they preferred an appeal. And, my lord, appeal is, my lord, fixed on 16. So this matter may be tacked with. And on the other hand, my lord, whether lordship will take up the matter or not. Otherwise, there is absolutely no bar.
You want to take fresh step?
No, my lord, the appeal, my lord, they preferred an appeal. The respondent authority, they preferred an appeal before division bench, which is fixed on 16. So, my lord, for time being, contempt is, my lord, whether contempt is, my lord, otherwise can be proceed or not, it may decide by
So,
the.
Mr. Tapen, you have preferred appeal.
Yes.
Okay.
Appeal is,
Therefore, my lord, my-
delay was condoned
Yes, delay
on
was condoned,
7th of this month.
and matter is fixed on 16. So this matter may be tagged with the, my lord, appeal.
Otherwise, lordship, if lordship see the order dated 7th of May, lordship, it is supposed to be listed on 16/6, lordship. Why it has come out today, lordship? They have, I think, mentioned.
We have mentioned.
Why it has been mentioned now, lordship?
That's why, my
Okay,
lord, like-
let it be taken with that appeal then.
Yes, sir.
That's already there, lordship. Because lordship will find the order is, it is already fixed on 16 of 6, lordship.
No, yes, it is fixed, but no order has been passed.
No, order is there, lordship. Yes.
No, it is only stated that on the pair of the learned counsel for the petitioner.
Can you see the order dated 7/5?
Yes, only one line order is there.
Yes.
Lordship, I have just checked and it was there, lordship.
No, this is a. No, here there is direction to list the matter on 16/6.
16/6.
Yes,
That's what, lordship.
We also don't know, my lord, how the matter is.
It is supposed to be listed on 16/6, lordship. This contempt matter, lordship. They have mentioned it for today. Why it has come?
No, we didn't mention. No, don't say in that.
I have find one mention memo there.
There is no mention. We have never made any mention.
It's dated
Okay, and then 16.
16.
16.
Heard Mr. Prokestal, learned counsel for the Petitioner and Mr. Tapin, yes, Tapin.
Mention
Who
no
is
is here.
the respondent? Uh,
Wait something.
It appears that High order dated 7/5/2025. It has been directed the estate to lease the matter on 16/6/2025. Accordingly, it is provided that the registrar shall lease the matter on 16/6/2025.
Lordship.
My lord, in this case, my lord, await service review. Contempt matter.
Heard Mr. A.K. Purkasa, learned counsel for the petition. Office note dated 23rd/5/2025 indicates that service report in respect of sole respondent is still awaited. Lease the matter after 2 weeks.
My lord,
Awaiting service
Court may
report.
fix the matter on 16. 16 I will come. my lord.
16. 16. Awaiting service report upon the respondent.
Obliged.
Lordship, service is completed, your lordship.
Service completed.
Yes, your lordship.
Whether the defendant, oh, sorry, respondent centered evidence. You are for
For respondent number 1, sir. I'm appearing for Mr. M. Kato, DSGI.
M.
M. Kato.
M. Kato. But his office note indicates that service report in respect of 4 and 8 are still awaited.
Lordship, I have instruction to appeal on behalf of respondent of 5, Lordship.
Respondent number 5.
5, Lordship. I'm going to file my power today, Lordship.
Okay. Heard, Mr.
Lordship, P.
Your name?
Wangpan. P. Wangpan, your lordship.
Learned counsel for the petitioner and Mr.
T. Meto, your lordship.
Learned counsel for respondent number 1.
Yes, yes,
And
lordship.
you for
I'm S. Sutradhar for respondent of 5.
S. Total for respondent number 5. Office note dated 23rd/5/2025 indicates that service report in respect of respondent number 4 to 8 are still awaited. You want to take fresh step?
Okay, your lordship, I can do.
Okay, the learned counsel for the petitioner submits that he will take fresh step upon respondent number 4, 6, 7, and 8. 7 and 8. Accordingly, it is provided that step upon the aforementioned respondents shall be taken by registered force with ADN also by usual process within a week from today. Less the matter after 4 weeks.
Lordship, in respect of 5, I'm appealing. 5. I'm going to file power.
Yes, sir, we have.
Obliged.
The learned counsel for the respondent number 5 submits that he will be filing his Wakalatnama power during the course of the day.
Yes,
today.
Lordship.
Yes, your lordship.
In this case, I'm appearing for the FCI respondent, my lord. By last order date is 7/5/2025. Petitioner was supposed to file rejoinder on or before 22/5/25, my lord. The matter is urgent in the sense that, my lord, we have floated a tender, they have got the stay. The interim order is, my lord, dated 8/4/2025, wherein the court is inclined to stay the finalization and not take any steps, my lord. The order is like this, my lord. So, my lord, petitioner is silent whether they have applied, they have bidded in this NIT or not. We need to know, at least technical bid may be kindly be opened, because they will not be prejudiced, my lord, for effective adjudication of this matter. Because of the this interim order was ex parte, my lord. At least technical bid may be open, my lord, because it will be not be prejudiced. There are 2 stages for finalizing of the NIT, my lord. First technical bid, thereafter evaluation, then price bid is to be open. If after opening the technical bid, we will come to know whether the petitioner has applied in this NIT also or not, my lord. Initially, there was a NIT, my lord, which we have floated, but having found the price is too high, we have cancelled that NIT and we have floated the ad hoc tender. And ad hoc tender, the petitioner has applied and got the tender, my lord. Now, subsequently, we want to float the regular tender. So this regular tender was again challenged, my lord, on the count that the first tender was cancelled, my lord. So for effective adjudication, we want to know whether the petitioner has applied for this tender or not. Only after the opening of the technical bid, we will come to know, my lord. Only that part, my lord, the liberty may be given.
Yes,
But
madam.
meanwhile, they are filing, I think, after 3 days, the rejoinder, my lord.
My lord, we'll be needing some time, your lordship. Within this week, we'll file our rejoinder, your lordship, and the interim, it may not be vacated or it may not
No,
be.
I'm not asking for vacation, only
Okay.
for the technical bid, we will open.
My lord, it
Interim
may not be
is
allowed,
not to
otherwise.
finalize, we will not finalize. Because, my lord, effective adjudication, my lord, if they applied for the, if they bidded in this present NIT also, my lord, they will be,
No, no,
stop, my lord. The law
uh,
point will be in the favor of the Food Corporation of India, my lord.
Let her file rejoinder.
Yes, your
I
lordship.
mean,
within a week
let
from
them
today.
be directed to state whether they have applied for the or not.
Within a week from today,
Yes, your lordship.
thereafter we will finally hear the matter.
That is okay, my lord, but only we want to know whether they have applied in this tender also or not. They are silent in their writ petition. We will only come to know after opening of the technical bid, my
My
lord.
lord,
We are not going to finalize it, my lord. Just we'll come to know whether where the bidders, my lord.
my lord,
This
may
will
not
be,
allowed,
this
my
will
lord.
be,
We have made
this
serious
will be
allegations
necessary
against
for
the respondent
effective
authorities, your lordship.
adjudication of this matter, my lord. Only technical bid. Because my lord, the interim order is like not to finalize. We will not, we have definitely will not be finalized, my lord.
My
If your
lord, there
lordship
may
will
not
see
be any
the,
alteration in the interim
see
order, your
the
lordship. Since we have
interim
made serious
order
allegations against the respondent
dated
authorities, your
8/4,
lordship.
2025 at page 5, my lord, paragraph 12. The court is inclined to stay the finalization and not take any steps in respect of tender number dated 25/3/25 till the next date of listing.
No, if is the order of the court, then where is the bar in opening the technical bid?
There is no, but the
Then-
authority is apprehensive that they might file contempt that now why you have opened the technical.
No,
If
if
liberty
there
is
is no
given, my
such
lord,
direction, then where is?
that may be observed, my lord, only
No.
No, your lordship, that
technical bid opening will not be final. We are not finalizing it, my lord.
No.
Technical bid, then price bid.
There is no bar as such in this interim order that you cannot open the technical bid. Why should we pass such a direction? Well, there is no bar.
Okay, my lord, then we will open it. My lord, they wanted three days time, my lord. Next week may be fixed for the admission disposal, my lord. On third.
Whether you will be able to file it within 3 days,
we'll be
Yes.
filing within this week, your lordship.
within this week.
Yes, your lordship. Next week, the matter can be listed.
On 3rd of June, my lord, admission disposal.
Third, Miss the term of learned for the petitioner. Then Mr.
BK Singh for the FCI respondent. my lord.
DK Singh, learned counsel for the FCI respondent.
FCI respondent, respondent number 22.
Respondent
Six.
number 2 and 6. And you?
Catering for DHA, Mr. M. Kaka.
For
DHA, Mr. M. Kaka.
Respondent 1.
Respondent.
respondent number 1. Respondent number 1. Ms. Tamuk submits that she will be filing rejoinder affidavit within this week. Accordingly, it is provided that recessal is the matter.
On 3rd June, my
One
lord.
week,
3rd June, my lord.
3rd of June. Okay. 3rd of June.
My lord, endeavor will be made to dispose of this matter because there is a time limit now. It is
That's all
from the
provided
JAM
she
portal.
file her affidavit. Rejoinder affidavit. You file it.
Yes, your lordship.
For admission, my lord.
My lord, the interim
Recessal is the
order,
matter for admission.
my lord, the interim order may continue, your lordship. Interim order passed earlier shall continue.
Okay, interim order pass early shall continue.
Obliged, your lordship.
Obliged, my lord.
May I please, Lordship, item number 12, Lordship, I was occupied at the other court, Lordship, that's why, sir.
Item number
12, Lordship.
Okay, we'll call again it after adjusting the list. Sit down.
Okay. Obliged.
Yes, next item.
May I please, Lord?
Yes.
Yeah, steps are taken to all the respondents. And they are supposed to file affidavit.
Yes,
Yes,
madam.
Lordship. I'm on behalf of respondent number 2 and 3, Lordship.
Respondent number
2 and 3.
2 and 3.
Respondent 2 is SP Superintendent of Police and 3 is IO, Lordship. We have received the Lordship status report of the PS case number 4025 as well as the written revised comment, Lordship. So we'll file our reply, Lordship.
Come on. So respondent number 5, you are appearing.
2 and 3, Lordship.
2 and 3.
Yes, Lordship.
And you? Respondent number 1. With the service completed in respect of respondent number 5.
Number 5, step was taken.
Step was taken.
Yes.
Heard Mr. D. Bozen, learned counsel for the petitioner. And Madam L. Hagen, learned counsel for the respondent number 2
2 and 3.
2 and 3. And Mr. Learned senior government advocate for respondent number 1. Respondent number 1. Office note dated 23rd 5 2025 indicates that service report in respect of respondent number 5 is still awaited. This is a list the matter after 2 weeks. 2 weeks.
After 2 weeks, Lordship.
After 2 weeks, awaiting service report upon respondent number 5.
Lordship,
In
after
the-
3 weeks late, Lordship. After 3 weeks.
After
Because
3 weeks.
2, 4 and 5 is supposed to be appear, Lordship.
Yes. No. In respect of respondent number 5, someone has filed a color number.
Okay, Lordship. 4 is only remaining 4. Respondent 4. 5. Okay. 4 already, Lordship.
Four
Baka
already
naman
filed a
is
color number.
Lordship.
In the meantime, the respondent number 2 and 3, respondent number 1, 2 and 3 may file their affidavit in opposition. List the matter after 3 weeks.
Like,
Obliged. Please, your Lordship. Lordship, service notice is still awaited to respondent number 9 and 10. So your
Respondent
Lordship,
number 9 and 10.
9 and 10.
Okay. Heard Mr. Bhattacharya, learned counsel for the petitioner, and
So,
Mr.
Your Lordship, I
Harish Nawab,
pray that
learned
I be allowed to take fresh
Advocate
steps.
General for respondent number
9 and 10. Your
I
Lordship.
Malat, respond number Malat 3, 4, 5, 6, 7, 8, 11 and 12 Malat.
Okay. And info?
Respondent number 1 and 2.
Respondent number 1 and 2. Office note dated 23rd 5 2025 indicates that service report in respect of respondent number 9 and 10 still awaited. Raises a list the matter after 2 weeks, awaiting service report upon respondent number 9 and 10. Or you want to take crisis?
Meantime, your Lordship, I'll take fresh steps by
Okay.
register edipos as well as Dusty, your Lordship.
Okay. Mr. Bhattacharya, learned counsel for the petitioner, submits that he will take fresh step upon respondent number 9 and 10. And he also applies for according him permission to effect the service upon them by Dusty pair allowed. Rest is the matter after 2 weeks or 4 weeks.
4 weeks Malat, then 3 weeks
Yes,
to
your
take
Lordship.
fresh.
After 3 weeks. It's up
3
to you.
weeks. Okay, 3 weeks then. 3 weeks.
Obliged.
My pleasure. My lord, this is all matter since 2018, my lord. But however, my lord, I have been informed by the council from the government, my lord, that because of her certain work, she is not able to appear to. So in such situation, my lord, can it be on 29, my lord?
This month.
My lord. Because, my lord, my argument in absence of the other party will be, my lord, nothing wastage of time, my lord.
Any objection, madam?
No, my lord.
Yes, madam. Lordship, a press for listing the matter on 29th. Any objection?
29 of which.
29. Lordship, just let me check. May 29, Thursday. Lordship, let it be on 3rd.
30?
3rd, 3.
3rd of June? Okay,
Yes.
okay. As agreed by learned advocates of both sides, recessal is the matter on 3rd of June.
Much obliged, Lordship.
I'm for respondent number 6.
Pardon?
I'm for respondent number 6. Additional. We file additional affidavits.
You
Yeah.
will file
Yes.
when?
18-3.
So are you supposed to file this affidavit in a reply?
Yes.
Yes, Your
Yes, we have not received the reply.
Have you filed?
No, Your Lordship, actually this matter, it was disposed of, Your Lordship, disposed of this matter. And the honorable, it was taken up in the a review petition was filed, Your Lordship. And after that, the matter was again reverted back to before the single bench, Your Lordship. And that is why this matter has come up now for the first time, Your Lordship. May I pray that some time may be given us for filing the needful, for doing the needful, Your Lordship.
Ordinance date amount, learned counsel for the petitioner and Mr.
Enkuru.
Learned counsel for respondent number
6.
6.
Yes.
And
Respondent number
for
6.
Two, 5 March.
1 to 5. 1 to 5. Ms. Tamam submits that she may be granted some time to file the affidavit in reply. There is accordingly allowed. Recessal is the matter after 2 weeks or 1 week.
After 2 weeks, Your Lordship.
After 2 weeks.
My lordship, in this case, kindly see this issue is very simple, lordship. We are the agri project affected family. In this case, we have filed a representation before the authority because there was a left out cases. And our lane was not properly assessed. So we have filed representation accordingly, page number 37, annexure 5 of the writ petition. The authority has issued an order saying that genuinely left out cases has to be resurveyed. But it was only 2 days. It is a very far-flung area. From the office, it was 2 days, and we have not been informed of. That is why we could not participate in within the 2 days. Because order was passed on 27, it was to be carried out on 29. And Thereafter, when we reported to the office, we have been informed that process is already over. So we filed representation before the competent authority and it is pending. That is why, yeah, in terms of, that is why, my.
Where is the copy? Page
Kindly
number?
see page number 37,
37.
annexure 5. On the basis of our request letter, the representation, may I read the contents? In pursuance of the ADC letter number such and such on 27 September 2003, Ajin Nakar Mondal and DLR Ratio in Kyong and Bopak such and such are hereby directed to proceed to the meeting. This is a very powerful area for joint survey work of genuine and left out cases of meeting to Tooting BRO Road, which is going to be start on 29/9/2023. So on the basis, this order was first on the basis of our request, saying that our.
No, where is your representation?
Kindly see the representation is page number 32, annexure 4. It was our letter was to the deputy commissioner concerned, saying that immediate reassessment. Accordingly, on the basis of this DC order, deputy commissioner order, this order was passed, saying that our grievances will be looked into. So since then, the project is yet to be started also. Project is not has not commenced although this is the problem. So our limited prayer of this honorable of the petitioner is that this in terms of this order, since we have filed representation on the basis of this citing these regions, because within the 2 days, because it is a very remote area, and this order was issued from the headquarters. And the place itself is very far-flung area, so we could not participate in within that prescribed 2 days. That is the issue.
Mr. Nabam, any objection in issuing direction to dispose of this representation?
Yes.
My lord, so far my dispose of representation concern, my lord, I don't have any objection. But only the deputy commissioner says, my lord, because complaint, the reassessment was done. But while doing that, they remain absent. Perhaps, my lord, some communication gap is there. Now they are saying, my lord, they have not received any notice from the deputy commissioner, my lord.
Yes,
So, my lord,
not received.
this representation, this address to the deputy commissioner, this can be disposed of, my lord. No problem for that.
Okay. So do we fix a time within 1 month?
Within, my lord,
4 weeks from the date of receipt of certificate?
Yes, my lord.
We are disposing of this.
Well,
Taking lordship, taking into consideration of this order, previous order saying that the genuinely left out cases will be looked into because
The deputy commissioner order.
because within that short time we could not participate in
Okay.
in the post. That was the issue. Order permission.
Aisyah na ko betul apa? Gina masalah? E-file. Huh? E-file. E-file. Letter, Mr. E. Payam, Learned Counsel for the petitioner, entered appellates. Okay.
दो बजे को होगा ना
नहीं स्टेप फिर से लेना था
Lordship, I would like to mention item number 3. Matter may be taken up next week.
next week.
Yeah.
Yes.
For the petitioner.
You are Mr.
Yes, Yirang, on behalf of El Parme, standing counsel against
Mr.
Dr.
Sunsol, learned counsel appearing on behalf of Mr. L. Parme. Learned counsel for the respondent with concern from the other side, press for listing the matter on
Next week. Lordship.
next week.
2 or second, my lord? Second or
2nd
third?
of June.
2nd of June.
Okay, okay. Fair load.
Okay.
Highly obliged.
May I please, Your Honor? And I beg to mention item number 5.
5.
And in this case, I've already taken consent from the petitioners. And this matter may kindly be fixed tomorrow, Your Honor, because the conducting counsel, Mr. M. Pertin, is out of station.
When do you want?
Pardon, Your Honor?
When do you want?
Tomorrow?
Tomorrow.
Yes, Your Honor. Or any date that is convenient according to this honorable court.
Ms. T.Y. Bhutia, learned counsel for the respondent. You inform the other side?
Yes, yes, Your Honor. I
With
have.
consent from the other side, press for listing the matter tomorrow. Fair load.
Deeply obliged.
May I please, Your Lordship? I'd like to mention item number 9. I'm the LSE of this case, JLAP litis. I already took the consent from the PP side. May, if possible, my lord, may fix on the 17th of June as a fixed matter.
Item number 9.
Item number 9. my lord.
I am Naveen Kumar. I am appearing through VC Milord in item number 9 and 10. Milord, my lord may refer to last order. Milord, they are seeking adjournment here, but on other hand, they are going to auction this area, Milord.
This is
So
criminal appeal. Criminal appeal.
Oh, I'm sorry.
Jail appeal.
Oh,
This is
this-
jail appeal.
no, I am referring to Parsuram Cement, Milord, writ number 175 of 2023.
No, this is different.
You are.
Which side?
This is item number
9.
9.
Criminal appeal.
Criminal appeal, madam.
3623. This is a jail appeal.
Sanglong Bangyang.
Sanglong Bangyang.
Sanglong Bangyang.
It's
item number 8.
That is item 8.
9. 8.
Maybe variation in the procedure. Here is reflected at 9.
Yes, it is 8.
8. Oh. Yes. Mistook ladali.
9.
Oh, okay. 8.
Here 9.
9, 8 to 10 buildings. Okay, 8 to the bench.
Okay.
8.
Okay, 8, your lordship. In the court,
Lordship,
for
this
this
is
is 8,
confusion
your
for
lordship.
the
Okay, okay.
Your Lordship, let it be listed on 16, Your Lordship.
16.
Yes, Your Lord, Monday,
No,
June.
it's 17 of Monday.
Is there your good name, please?
Yes, my lord.
Good name, your
M. Bagra.
M. Bagra.
Already fixed मेरा.
Learned legal aid counsel.
Yes.
Consent from the other side, press for listing the matter on
17.
17th of
Okay.
June.
17 June. Fixed matter.
Okay. There.
Oblige.
Oblige.
These two matters, my lord, I have been requested to appear considering the financial implication involved. But apparently there was some issue regarding extra copies and all that. I am not on that. My young friend has managed to give me a copy. I've gone through it, my lord. Some of the most relevant materials don't seem to form part of it. We will be required to file an affidavit. So your lordship will allow us some time.
In item number 2, my lord, some requisite copy they yet to start, my lord. I requested them, but.
In fact, the most relevant notifications that have not even been brought on record.
Fifth pay commission benefits have been given.
Fifth given, sixth given.
Revised, that you had taken a decision that you will not give the areas from 98 to 2013, from April onwards.
And that 2002, your lordship must have noted, it is not even not there, and it is not even meant for the states. It is for the union territory. We have adopted.
And their parent organization had accepted.
Accepted.
They formed a splinter organization.
They are saying.
And they got wiser later.
They are saying, my lord, financial crisis at one point of time. Then subsequently they twisted, saying that it is a policy decision. They never said, my lord, we have paid.
But Mr. A.K. Professor, Learned Counsel for the Commission, also heard Mr. I. Chaudhary, Learned Advocate General, assisted by Mr.
T. Tagum,
Learned Standing Counsel, Education Department. So, Mr. Tagum submits that the state respondents would like to prepare a decision and affidavit to bring on record materials, relevant documents on record, which would have a bearing on the consideration of the issues arising in the present writ appeals. So, prayer accepted, registry, the matter stands adjourned today, registry to discuss matters again after or on 28.
According to my lord, they have chosen a date,
My friend was asking for after 20th of June, but that week, my lord, I have a problem. I'll be out of station. If it is not inconvenient, can it be after the reopening?
2028?
28th of
Already
July.
suggested.
28, 17.
And my lord, in the meantime, my lord, if they file affidavit, we may be given the liberty to.
That liberty they will have.
That is already a step.
Obliged.
Obliged.
Who is for the applicant? For the petitioner?
On last occasion also, they
Remain absent.
they were absent.
Okay. Could take them. None appears for the petitioner on call. How about Mr. T. Tagum and Mr. S. Tapin, learned senior government advocate? For the respondent number?
I'm for 1 to 10.
1 to 10. And Mr. Tagum for?
I am for 13, ma'am.
13. 13 to 15. 13 to 15 present.
list the matter after a week. In the event of subsequent non-representation of the petitioner, appropriate orders will follow.
My lord, I am for the item number 6, my lord. I am for the petition.
Yes.
My lord, kindly see, where is the last order that is on 21, my lord. My lord, so far the response number 1 and 2 is, my lord, they are being represented, and the 3 service is complete, and the 4 has filed their counter, my lord. And the direction was given to, but they showing the reflecting the name of the SC Kyle as response number 3, and matters should be listed for admission. But I have seen that my Kyle name is not there.
May I, Lordship? Sorry for the interference. Sir, I'm appearing on behalf of M. Kato, the SGI. Sir, due to health issue, he left the court premises, so he won't be able to attend. So I pray for next step.
Adjournment.
Sir, yeah,
When? Next week?
yeah, sir. Next week.
My lord, my one prayer, my lord, so far the response number 3 is the service is complete, but till today, my lord, no count, this power has been filed. So, my lord, if it is not filed, then matter may be come up for the admission the next date, my lord, because the matter is relating to giving upgradation promotion of the, my lord, the lecturer, associate professors. Those degrees are having the, my lord, B Farm with the MTech in biotechnology, but that was in subsequent development was there, that the pharmacy council, my lord, they, while promulgating the education rules, they did not enter the, my lord, B Farm with MTech with the, my lord, biotechnology. So to be considered for the next promotion and their qualification. Though earlier that was the, my lord, AIACT, the qualification was recognized to be, my lord, qualified to be appointed in the pharmacy council colleges, my lord. So this is the issues, my lord. So so for the response number 4 is filed their counter. So that may be come up for the admission the next date, my lord. And all the parties if required, they will file their counter also by this time, because service is complete.
Heard Mr. P. not only counsel for the petition, also heard
Irini.
for the petition.
Yes.
For
Yes,
respondent,
she's my
for respondent, all the respondent, for all the respondents. Team Your Lordship.
Also heard Mr. P. Meadow representing Mr. D. M. Kato, learned Deputy Solicitor General of India, appearing for the response number 1 and 2. So, it is seen that the service of notice upon the response number 3 is complete. However, none has entered appearance on their behalf. So, in view of the above position, Mr. Kato, learned Deputy Solicitor General of India, is required to receive instructions from the response number 3, that is the Pharmacy Council of India, and apprise the scope of the stand of the said authority on the next date of listing. Registry is after 3 weeks on a date.
My lord, if it is possible, one date may be given, my lord. That will be convenient for me.
3 weeks. Registry is to business matters again on 16, 16,
16?
16/6.
16/6.
Your Lordship, regarding respondent number 3, I have already filed a dusty service.
This is already there. It is already there.
God bless you.
Master placement.
May it please, my lord. My lord, this is criminal appeal, jail appeal. I have been appointed as amicus curiae in this case, and on the direction of this honorable court, I have filed a memo of appeal, order dated 31/7/2023. I have been appointed as amicus curiae and directed to file a memo of appeal. And on 23/1/2024, in order sheet, it is reflected that I had filed appeal. And 1/7/2024, the private counsel has appeared for the appellant. So my name may be struck off since private counsel has already been engaged by the appellant. On 1/7/2024, private counsel N. Langen is appeared.
Lordship, Wakalat Nama has also already filed, Lordship. On behalf of N. Nangin, Lordship.
So Mr. Duncan will be appearing in the matter.
Yes, Lordship.
What is your name?
Honita Natara, Lordship.
Heard Mr. Swanson, who submits that Ms. D. Duncan, D.
N. Dangin, Nikita Dangin.
Learned counsel shall represent the petitioners, that shall represent the appellant in the present criminal appeal. So he submits that the name of Ms. N. Duncan has not been reflected in the cause list. So, your name, ma'am?
Jaya Doji.
Ms. J. Doji, who was engaged as the amicus curiae in the matter, is present and submits that in view of the engagement of Ms. N. Duncan, she may be relieved
Yes.
of the from the matter. So, in view of the above position and Ms. D. Duncan having been engaged by the appellant to represent him in the matter, they raised to list this matters again after.
When do you want?
Maybe after 2 weeks, Lordship.
After 2 weeks.
Yes, Lordship.
After 2 weeks, the name Ms. N. Duncan as learned counsel for the appellant. So, in view of the above, in view of the fact that Ms. N. Duncan has entered appearance on behalf of the appellant, Ms. J. Doji, amicus curiae, is relieved of is relieved of the matter. Also, however, if you see that Ms. J. Doji had taken steps for filing of the criminal appeal before this court, including preparation of the appeal and according to registry to release to Ms. J. Doji her due remuneration in the matter.
Nice.
Lordship.
These two matters, provision of a central act is under challenge. one, in respect of item number 9, it's a slightly old matter. We have already filed our affidavit. But I don't know about the position of the central government because they are the main contesting.
My lord, I am
so
appearing
far
for the
as
petitioner, my lord. Let me show the urgency, my lord. My lord may refer to last order, 19th May. My lord has recorded that they are going to auction this area, my lord. So they are going to open the technical bid. And if that is done, my lord, my petition will be rendered infructuous. Notice was issued in 2023, my lord. My petition is pending. State has filed counter. Central government is not filing. Center was directed number of times to file the counter, my lord. So they should maintain a status quo, my lord. In similar cases, my lord, Madhya Pradesh High Court, Chhattisgarh High Court, Karnataka High Court, even Supreme Court has granted a status quo order, my lord. May I show those orders, my lord? I have filed the order of Supreme Court in my IA 23, my lord. Supreme Court has also granted, Lord, this matter was decided in favor of the applicants by the Karnataka High Court, my lord, in Indosil. That Indosil matter has traveled to Supreme Court. Supreme Court has not granted a stay against the judgment of Karnataka High Court, but Supreme Court said that a status quo shall be maintained. That order is annexed with the IA, my lord. IA 23, my lord, page 23. The Supreme Court order, my lord is there, page 23. In a state of Karnataka and other special Indosil, my lord, order dated 2nd November 2022. Last lines, my lord, let the issue be noticed. Then respondents are liberty to file counter, list the matter, and pending further consideration, parties shall maintain a status quo as it exists today. So, in similar matter, my lord, Supreme Court is seized with the matter. Karnataka High Court has decided in favor of the applicants. Supreme Court has said that a status quo should be maintained. I am seeking similar prayer today, my lord, that on one time they are not filing counter. Central government was directed to file counter in August 2024, then January 2025. They are not filing. So they should maintain a status quo at least, my lord. Otherwise, my writ will become infructuous. And in similar case, my lord, if I show in my case, my lord, to in nutshell the facts, I was granted prospecting license in year 2014. I have completed the prospecting operations in 2019. The state government was satisfied with my work and they have granted LOI. That LOI is, they are not deciding. I have filed a writ petition. Writ petition is pending since 2023, my lord. The notice was issued in this writ petition on 29 May 2023. A state has filed counter. In fact, a state has written letter to the central government that the state of Arunachal Pradesh requires investment and these leases should be granted. But center has on erroneous view, my lord, said that you go as per the law, my lord. So I am saying, my lord, that at least 3 high courts and Supreme Court has granted a status quo. One high court, that is Karnataka High Court in division bench, has decided the issue, similar issue, and the High Court has held that in those cases where PL has been completed,
Mr. Khatoi, why have you not filed an affidavit in this matter? We have made correspondence in the complaint of we haven't received any instruction.
In fact, what had happened was, originally they had not even made Union of India party. Subsequently, they have made. After that, perhaps he has communicated. That is why instructions might not have
If
come.
the prospect, if the mining lease is auctioned tomorrow, what would be the effect on the petition?
It will always be subject to outcome. If your lordships strike down the provision, ultimately your lordship is a statutory provision under challenge.
My lord, may preserve the mineral block, my lord. A status quo should be there. Otherwise, they will create third party right. The matter will become complicated, my lord. And it is only 2 blocks, my lord. They may go with the other blocks, but my subject mineral block may be preserved, my lord.
Mr. Kumar, in your second case, you have not even challenged the provisions of the rules.
I have challenged, my lord.
The
I
second
have
case.
challenged.
In-
Yes, yes. In both cases, constitutional.
Well, it is the second case.
In the second case, it's a fresh matter. We need to file our affidavit.
No, second case is the challenge to the rules.
Yes, my lord. I have challenged 10A to be.
But a mere challenge to the rules also will not be enough. The proviso has to be challenged.
No, my lord, that I have challenged the proviso which has been inserted
So,
by
Mr.
way of
Kumar,
amendment.
Mr. Kumar, a statutory provision is under challenge. We'll have to take a call whether the statutory provision is liable to be interfered with or not. Till it is there, the constitutionality of that would be presumed. Should be
Lord, I
presumed.
have, yes, I am obliged,
So,
Lord. My lord has
Mr.
put the
Kumar, if
counsel.
tomorrow we decide the matter in your favor, any action taken in pursuance to that will go. We'll make it clear.
Lord, once, ma'am, I am very deeply obliged, Lord. I have, my first prayer is that as per the proviso, my right is not curtailed, my lord. And that is what Karnataka High Court has
That
held
is
in
what we will
Indosin.
examine. That is what we are called upon to examine whether
Yes, ma'am.
that interpretation of 10(2)(b) is correct or 10(2)(b) is a part. That's all.
Yes, ma'am. So today, my lord, my lord, today, my lord, today I am only as a prima facie case, my lord, that Karnataka High Court, relying on Supreme Court judgments, has held that in those cases where PL has been completed and ML has been applied, those cases are not covered by this. My lord, may have the judgment of Karnataka High Court, my lord. It is very beautifully written judgment, my lord. It is there with my learned counsel, my lord, who is there, Mr. Munjim. He will give the copy of judgment, my lord. And the judgment clearly records that the proviso will
We'll
not.
consider that, Mr. Kumar, we'll consider that. Let the meetings be completed, we'll consider everything.
Meanwhile, my petition will become infructuous, my lord. They will create third party right, my lord. My minimum block will go.
We'll make it clear.
Yes, my lord. That observation may come, my lord, that they will not go ahead with this. These
That we
mineral
will not
blocks.
say. We'll say pendency, that pending the writ petition, any steps taken would be subject to outcome of the final outcome of this case.
That will, my lord, they will go ahead and create rights, and then my contenders will come. They will start doing all that, my lord. My lord may decide at early date. Let them wait for 2 weeks, my lord. Let them file counter. I'm not saying that indefinitely a state. Just take a status quo till next date, and my lord may have it next week.
These are matters which also involve the finance of the state involved. So we don't want to prevent them. If anything happens,
my lord. My lord, the state has written letter to central government that giving it to me will be more beneficial, my lord, because I have invested huge amount there. The state government has written, my lord, and they have filed that letter with the counter. The state chief minister has written to central government saying that I have done the investment, and
When he
I
submitted
should
a
be relaxed.
representation to us, we
Kindly see their
forwarded
counter
it to
itself.
the central government. Central government said that no, you have to go by the law. The law as it stands.
So
And
law,
we are bound by
is
that.
favor, my lord. Law says that the vested rights, the rights which are finalized are not taken over by this proviso, my lord. The Karnataka High Court has relied on Supreme Court judgment and said that the proviso will not eat out the entire provision. So provision has not been deleted. Main provision which confers the right is there. It is still there. So Karnataka High Court has dealt that only those pending cases where PL has not been completed will be taken over by this proviso, my lord. And I am saved in the main provision. So main provision saves me. Main provision saves me. I am before my lord. I have a good prima facie case. They are creating irreversible prejudice against me by going ahead with the auction. So they should maintain a status quo. And my lord, all high courts, Madhya Pradesh, in fact, Chhattisgarh High Court was the case of auction. And Chhattisgarh High Court, my lord, see that orders, my lord. Chhattisgarh High Court has said that you will maintain a status quo. I have shown the Supreme Court order, my lord. Then Chhattisgarh High Court has also said that you maintain a status quo. And that was for the auction only, my lord. It is in Jindal Steel, Jaiswal Nico, my lord. Page number 27. Chhattisgarh High Court says that 16 matters are pending before division bench of Madhya Pradesh High Court, and a status quo in respect of that has been granted. So all high courts have granted a status quo, my lord, in all similar cases involving 10A2B. My lord is there, page 27 of my IA 23, my lord. Page 27 of my IA, Mr. Annexure B. The Chhattisgarh High Court is recording at page 28, third para, my lord, referring to so and so in 16 matters pending before division bench of Madhya Pradesh High Court. A status quo in respect of disputed mining lease in the area in question has been directed to be maintained by the parties. And then after recording that, my lord, having heard the learned counsel for the parties for some time, and in view of the interim order passed by the High Court of Madhya Pradesh and Karnataka, we are inclined to grant interim relief in all matters. Let there be a status quo as it exists today in respect of processing of the mining leases for the subject area involved in the prospecting operations, my lord. So this is Chhattisgarh High Court, and it is relying on Madhya Pradesh High Court, which I have also annexed 16 matters. Karnataka High Court has decided. Supreme Court has also said a status quo. So Andhra should also, Arunachal should also follow the same, my lord. That is my humble request, my lord. Otherwise, read petitions will be infructuous, my lord, and all high courts have appreciated, my lord. Kindly appreciate in that light, my lord. That is what I'm submitting today. And I'm not seeking any adjournment. Let them come in within 10 days, 7 days. All division benches of the other high courts, my lord. And division bench of these cases will not have some persuasive value at least, my lord. I can't say it's binding, but it's persuasive, my lord.
Mr. Kumar, you are appearing for both the cases in both the matters?
Yes, my lord. Yes, my lord. Yes.
No, it appears. There are two repeats. But Mr. N. Kumar, learned counsel, appearing for the petition. Also heard Mr. I. Chaudhary, learned advocate general, assisted by Mr.
Kapin.
G. Kapin, learned S. Kapin,
S.
learned senior government advocate, appearing for the state respondents, and Mr. K. Terry, learned counsel, representing Mr. M. Kato, DYSGI, appearing for the respondents number, appearing for the respondent number 4. Also, Mr. Kumar has submitted that interim direction is required to be passed. Interim direction is required to be passed in the matter
directing the state respondents to maintain status quo with regard to the process of auction of the mining area proposed to be so carried out on 27th.
We are not very sure about the date exactly.
Carried out on 27th. Ms. Kumar, it's on
28,
27th.
Milord. 28, no, no.
28/5/2024.
They are opening technical bids on 28, Milord.
28/5/2024. Who's up? Mr. Chaudhary, learned additional, Mr. Chaudhary, learned advocate general has disputed the said position and has contended that in the present petition, the provisions of the, what is the name called?
Mines and Minerals Development.
Mines and Minerals.
Development and Regulation Act 1957.
The Development and Regulation Act 1957, more particularly provisions of section 10A, bracketed 2, bracketed small b, thereof is under challenge, and the court has to first adjudicate on the said issue. We have perused the materials available on record and find that the central government is yet to file its response in the matter, and in absence of the said response, it would not be proper for this court to adjudicate on the issues arising in the present petition. Also, in consideration of the submissions made by the learning council, Mr. So-and-so, representing Mr. Kato, submits that the affidavit on behalf of the respondents represented by him would be filed within a period of 2 weeks from today without fail. Also, in view of the above position and also considering the submissions made by the learning council for the parties, this court is of the considered view that an interim direction at this stage in the present matters would not permissible to be so issued. However, it is made clear that any step taken in the matter by the state respondents would be subject to the final outcome of the present petitions.
Can a date be fixed, Manoj, if it is not?
Fix a date.
17th of June, Manoj.
17/6/2020.
Manoj, in the other matter, it's a fresh matter. We are required to file the affidavit.
In the second matter.
And that has also not been admitted, I'm told. So
No, notice
it's
has
simply
been issued.
tagged together. Yes. So in this matter, we'll be needing some time to file affidavit.
Notice has been issued, Milord. Notice was issued on last day, and they have to file counter.
Heard Mr. N. Kumar, learned counsel for the petitioner, also say, repeat, Mr. S. Tapit, learned senior government advocate, submits that the affidavit on behalf of the respondent number 1 to 3 would be filed invariably on or before the next date of the also, Mr. So-and-so also submits that the affidavit on behalf of the respondent number 4 would also be filed on or before the next date of listing. As agreed to by the learning council for the parties, registry to list this matter again on 17/6/2023. It is provided that any further steps taken in the matter by the state respondents would be subject to the final orders that would be passed in the present petition.
Your Lordship, in the meantime, Your Lordship, we are filing paper book in item number 10.
Deeply obliged, no? Deeply obliged.